Hey, welcome everybody to Spin Legal. We had a week off last week, didn't we? It was Canada Day last week,
It's
so
Canada Day.
we were resting up, enjoying ourselves, and Spin Legal is back. So,
Spin Legal is back, and yep, after we said, oh, Canada Day.
well, there's one thing that's guaranteed, until at least Christmas. There's not actually another holiday on a Tuesday, even if Christmas isn't on a Tuesday, and I don't know whether it is actually. I haven't looked it up this year, so there we go. No Tuesday holidays for the rest of the year at least, right? Okay.
That's some
So,
interesting case laws that we're showing.
yeah. So we're going to deal with the topic of case law today. What is case law? How does it function and all that kind of stuff. So, it's an important part of the English style legal system that we operate here in Canada. Thanks due to the fact that we were a former British colony.
Yep.
Okay. So here we go. If you need to contact Invictus Legal, you can do so on 905-688-5598. Email Angela at weareinvictus.legal or myself at peter@weareinvictus.legal, or go to our website, which is weareinvictus.legal. There you go. So here's the first question. What is case law?
These are cases that have gone to court and have gone up to a higher court, and you have high court judges make a decision on a case on legal principles. They are answering a question, what does something mean in a statute? Everything in a statute sometimes is subject to interpretation.
Not just statutes, but
other cases sometimes when things happen.
Like, for example, the crime of murder is actually a common law crime. It doesn't actually, It's not codified by statute.
Yep. Yeah, so things like that are put up forward, and then they go up, and the highest court has the power, and they are binding on the lower courts and on the law too. So sometimes what happens is the higher courts can actually rewrite a law in the province.
Well, actually, it's an interesting thing. It's happened in Canada, it's happened in the UK, and it's happened very recently in the United States of America, where the Supreme Court of the land has actually reversed itself.
Yep.
It doesn't happen very often, but they have.
Mm-hmm.
Right? In three particular cases, and they've done it for reasons of advancing days, changes in how we understand things, what the new modern concept is.
Yep. Or even some decisions, like if you look at the Maple Trust case at the Ontario Court of Appeal, where the Ontario Court of Appeal reversed itself on a decision that originally was made against the plaintiff, and then afterwards it made in favor of the plaintiff, who was involved mortgage fraud, and who was the one who should be liable if there's costs or damages. And it's not the person who owns the home, it should be the people who should have detected the fraud and had more resources.
Yep. And again, so what is case law? Case law, to put it quickly and succinctly, is there are statutes that we produce, and most countries produce statutes. That's why we pay our parliamentarians to go into parliament, to not just endlessly waffle between themselves, but to actually make laws. So at the end of the day, they'll go nay, yay, and vote on a law. Case law basically takes those statutes and says, well, we agree that what the Parliament meant by this, but we're confused about what Parliament meant by the other thing.
Yeah.
Use case law so they can equate what case law exists prior to the statute, or even based upon things like Hansard, they can actually look for further meaning in certain words that are in the statute.
Yeah, and this is one of the things that sometimes there's a tension ongoing between the three parts of our system.
Yeah.
Okay? Like our judicial system, our legislature, and our system within our cabinet structure.
Yeah.
Okay? So there's always a tension. So you want to set up a pass a law, but then there's some people out there who are not going to like the law and they're going to try to challenge it. So there's always these types of things. It's a push and pull type of thing, okay, about how enforceable that law really is, and also whether or not this law passes charter muster or human rights type legislation, and what could be done about it. So there's a lot of things that it's that's what keeps us in business, Peter. That's why we get big bucks.
And the worst, and the well, I said the worst, but it isn't really. The interesting thing is, of course, about it is that you can pass a law today, and it doesn't really matter what it is. You know, the lodging bicycles on the side of the road law, right?
Hmm.
And then in 15 years' time, somebody passes a brand new law, which is, you know, again, the new lodging bicycles on the side of the road law that completely reverses the first law.
Yep.
Right, and
Yep.
that's part and parcel about how our system works. Case law only works to usually to enhance statutes.
Because a lot of times, like for example, we go through things like we wanted to know what the definition of a child was with
Yeah,
respect to the Residential Tenancies Act. Okay, so you go through the statute that doesn't really tell us a lot in the RTA,
yeah,
but however, we go through different things and it looks like there's more in terms of common law based on family law structure.
yeah,
So settled intention to raise.
yeah,
So there would be a child. So you could be an adoptive child, or it could be a child that you are raising and you've basically intended to raise that kid. Doesn't have to be a biological child.
yeah,
So there's a lot of different types of definitions. Okay? So that's basically what I found when I did a search. So
yeah.
there's different things. So it helps us understand, oh, my child's going to be moving in there. So it's not like you can go out in the street and say, oh, can you be a son for a day so that I could have you move in there so I could legally put an N12 on my property?
Yeah. Okay, okay. The next one. So, when was case law invented? You and I both love this history stuff, right?
Oh, yes.
So let's go straight to this. It's all about one guy. His name was William William of the Conqueror, as we call him in England. His name was William St Clair. He was the king of Normandy, and he invaded through the Battle of Hastings, the English mainland, and he's responsible for the generation of what we know as common law today. And basically, what he did is there's a number of judges around the circuits of England, and that's another thing that he invented. Circuit judges. So basically, a judge gets on on a horse and cart and gets from one town to another. So he goes to all the common assizes between all. They set up the common laws of England, which is
Yeah.
all of the all
This
of
has
the
always been the interesting how they started that out because
yeah,
they would talk to each other. Have you had a case like this before? Have you
yeah,
had a case before? How was that handled? What did it look like?
yeah.
And they would come up to some kind of agreement about how similar cases in the future would be decided. Okay? Like that was until we had a million of them. But these were the original types of things when they did this.
Oh, so Angela, you've got one of these in your office. Cheers, okay?
Cheers.
Because we are,
Coca-Cola,
yeah,
the
but
real thing.
we're not advertising Coca-Cola. We're going to Coke's Laws of England.
Yeah.
Coke,
And this is
Coke
not
is an interesting,
Coca-Cola.
yeah.
Has
This
nothing to
is
do with the drink.
nothing to do with the drink. Just our, so
Edward Coke.
Sir Edward Coke was a prominent English jurist and lawyer in the 17th century. So this is back in 16 whatever, and he has most notable for a case called Dr. Bonham's case, which is um, prohibitations in the land. So he did this case of prohibitations in a dispute between James I and Coke himself. and regarding the king's power to hear legal cases personally.
Yep.
Right. So Coke asserted that the king was subject to the law, and the legal matters should be decided by judges in the courts of law.
Yep. Rather than having the fusion of power stuff with the politicians.
Yeah.
Scary.
Yeah. And therefore, the king was prohibited to hear cases.
Yep. And I think that's great because it starts talking about the independence of the judiciary.
And
Okay?
yeah, the interesting thing is about this, of course, this is King James the First of England, who was King James the Sixth of Scotland. This has got to be 1650s. 1650s, 1660s, because this is the time when pre-unification between England and Scotland, but James was the first returning king after the what do you call it, the Commonwealth Parliament, right? That's where King James the First came onto the thing. So Coke also produced these things called the Laws of England. There we go. Spelled Lawes.
Yep. And that's how they spelled things back then.
Yeah.
Everything had an E at the end.
Yeah, I don't know about that, but I always love the ones that in the olden language that I always find weird is the S that is like an F.
Mm-hmm.
Right?
Yeah.
Especially the double, and it's weird that actually in England the F type of thing would be an S, but we would have double Fs, which would be SS, right?
Mm-hmm.
And in Germany they don't have that because they amalgamate that into the double S symbol.
Mm-hmm.
Right. It's and so we operate slightly different to our language cousin Germany. Okay.
Mm-hmm.
Okay. So so how does common law operate today? How does case law operate today? It's actually an important thing because we've come streaming up to the 20th century, and we get to this case called Donahue and Stevenson.
And anybody who's ever taken any courses and joined the legal profession, the snail in the bottle case.
But the interesting thing about Donahue and Stevenson is it's a foundation case in tort law because it produces the relationship between, it's about product liability and tort.
Product liability, foreseeability, a whole bunch of things.
Yeah, exactly. And because it brings together the manufacturer with the ultimate consumer.
Mm-hmm.
Because there's a contractual relationship between the manufacturer who makes a product and the person who buys the product, but there is not necessarily, in the case of Donahue and Stevenson, Mrs. Donahue
Hello, Peter.
I'm still. So the Stevenson factory made her bottle of what we would call Coke today, I guess. Her
ginger beer.
Ginger beer, I think it was. Yes, you're right.
Ginger beer.
But it had a snail in, not a snail. It's not a snail. It's a slug actually in the bottle, but we always call it snail. But anyway, so it had a slug in the bottle, and it only became clear when she went to pour it out into a cup, and it made her sick, of course.
Mm-hmm.
Right. But the point being is that up until that time, there was no relationship between the manufacturer and the consumer.
Yeah. And this is where we have a contract where there is something when you're buying something that what you're buying is you're agreeing to buy a bottle of ginger beer without a snail in it.
Yeah.
Okay. So like so basically this kind of tells you like a little bit about how that developed. So
Yeah.
it showed you
And
who's
the
liable.
other and the other interesting thing about this is
Due
that this,
diligence.
pardon me?
Called due diligence.
Yeah. The other interesting thing about Donahue and Stevenson, which makes the whole relationship between places like Scotland and England, in this instance, Canada and England, United States and Canada, Canada and and Australia, etc., etc. Donahue and Stevenson also put into play the principle that you can take laws from another land and apply them to your land.
Mm-hmm.
You can take common law that had been applicable in England, and you could apply it in in the case of Donahue and Stevenson, in the Court of Scotland.
Yep.
All right. So
And it
there we go.
applies here in Canada. It applies in the United States.
Yep.
Anywhere where there's a common law state system.
Yep. And some of the cases that we've got, and some of these are quite old, like Carlisle and Carbolic Smoke Ball, 1893, right? The principle in this one is beware what you advertise.
Oh, I've got to see you try to argue these things at court or at the landlord-tenant tribunal.
Well, the Carlisle and Carbolic Smoke Ball is the Carbolic Smoke Ball company advertised a reward of £100. And just to put this into context, in 1893, £100 could probably buy you a fairly good-sized home, right? It wouldn't be a 4 or 5 bedroom house. It might be a 6 or 8 bedroom house. It would be a real good house, right? So that's how you can put this into perspective. They offered a $100 reward to anybody who contracted influenza after using their product according to the directions on the packet. And what did Mrs. Carlisle do? She used the product religiously, day after day, exactly as Carbolic Smoke Ball said, and she contracted influenza.
Yep. And then she went to court, tried to sue, and they'd say, this was all a joke. This was not serious.
Yeah. And actually, there's an American case, the Pepsi Cola case, which bears some relationship to this.
We don't like Pepsi here.
No, I'm just using case law. Using case law.
Let's hear it.
I forget the name of the guy, but he basically there was Pepsi offered reward points, so you could get reward points off your Pepsi, and you could claim them for Pepsi prizes. In the United States of America, they advertised, "Hey, get 7 million points, you'll get a Harrier jump jet."
Oh yes, the jump jet.
Yes. Don't advertise a Harrier jump jet for 7 million points. Don't even advertise one for 700 million points unless you're seriously going to give it as a prize, because
Yep. And then they ended up with a nasty bill at the end.
PepsiCo a lot of money. It's the same type of thing as Carlisle and Carbolic Smoke Ball.
Yep.
So
got to have truth in advertising. If you're going to go out there and you're going to be promising some kind of promotion of some sort, you better follow through.
Yeah. Okay. So let's look at another case. This is interesting because this is Canadian. This is 2012. So this is in the era when we're not supposed to be inventing new cases, inventing new torts through the courts, are we? But yet Jones versus Siege did exactly that, didn't it?
Yep.
This is called the intrusion upon seclusion, isn't it?
Mm-hmm.
Tell everybody about that, Angela.
Yeah, this is a privacy case. The two people, Jones and another one named Siege, they both worked at a bank, and I guess Siege had developed a common law relationship with Jones' ex-husband, and then an action with damages was brought when Jones found that Siege had accessed her banking information 174 times over a period of 4 years.
Wow.
The issue in this case was whether or not Ontario law recognizes a right to bring a civil action for damages for that in itself as an invasion of personal privacy. The court ruled that there was, and a summary dismissal in a trial court judge of Jones' action for damages was reversed. So this got brought up to an upper court, and they said yes, there was a right to sue. Because initially the court dismissed it, saying there was no right to privacy in terms of a tort. Okay, so this was brought up to a court of appeal where they have a broader discretion and they use other cases from before. So this was based upon the recognized tort of misappropriation of personality,
Yeah.
and so must remain open to the proposition that a tort against invasion of privacy might proceed.
Yeah.
This was also the trend in case law. So furthermore, the Charter protects our right to privacy under Section 8 of the Charter. Although the Charter can't apply in a civil case, such as in Jones and Siege, but it can apply in a case where, say, it involves the government or the
Well,
state.
and a lot of this is because it was about personal, private records like
Yeah,
the banking records,
yep,
and the courts took it as highly offensive to invade financial or health records of sexual practices, orientation, employment, and diary or private correspondence.
yep, exactly. Because this was something that there is a foreseeability that accessing this type of information and then possibly what it could be used for could bring a great deal of distress to the offended party.
And the worst of this, of course, was that the defendant was actually it was intentional conduct of the defendant.
Yep, it's intentional conduct. It's not something
It's
that I
not, yeah,
accidentally came across.
yeah. Oh! Just I picked up this piece of paper. It's got Angela's financial details on it. That's I'm gonna not only keep it in my pocket. I'm gonna build a whole catalog of it.
Mm-hmm.
That kind of thing, right?
Yep, right. Okay. Or it could be just saying that somebody deliberately goes into some kind of database or whatever they were working for from a bank, which was something that they were not supposed to access, okay,
Yeah.
or to take that type of information without some type of permissions or reason for doing that. That's like police, like a lot of people have a police officer as a friend. Oh, I was wondering where this person lives, and this is the license plate of the person. Okay? This is why police officers can't give you that information, okay, unless there's a reason for the police officer to go in for it.
Well,
Like if
actually, there's
or somebody escaped in a car or something like that from a crime scene and they had that license plate.
yeah, but there's no reason for the police to give you that information.
Yeah, well, they
You know?
can't give us the
Yeah.
information.
Yeah. They can't they couldn't even give it to a lawyer, or
No,
judge
they
even.
can't.
They
Okay,
can
because that
they can
information
go
is
and
private.
investigate themselves. If
Yeah.
you say, I believe this car to belong to the the latest serial killer, I've
Hmm.
seen him drive, I recognize him, I've seen him drive it, he parked it here, this
Hmm.
location. I believe he might work or live in the area. Um,
Yeah,
that,
but that's when they have a reason to do this and to
yeah,
check it out. Okay,
yeah.
I'm saying they
The
can't just do
police
it
have
without a
that reason.
reason.
You don't. You
Even
know.
if a police officer has a curiosity.
Yeah.
I'm going on a date with this guy, and this is. But
Yeah.
however, if this guy is a suspect in a crime, yeah, you can check it out and then try to find out things. Right?
Yeah. Okay. So the next Canadian one we're looking at is Jordan, the Jordan Principle. This is
Hello, Jordan.
this is actually interesting because you said when I looked it up and I was like 2016. Are you sure? I
Hmm.
was swear that was a 1980s case.
This
But the
went up to
Jordan
the
Principle,
courts, and I remember when it was first decided, and this was because the court cases were taking too long,
yeah,
and people were going to the courts for years on issues.
yeah,
And then provincial offenses case, summary court offenses case, they were going on for years to resolve. And that causes a lot of distress because you don't know. You'd rather have the case decided and over with. And it's good
Yeah.
for people who've been victimized in some way to also have the case over with.
Well, and the interesting thing about that is that according to the decision, and it's because of the Section 11B part of the Canadian Charter of Rights and Freedoms that the accused has a right to be tried within a reasonable time frame. Jordan sets what that time frame is, and the interesting thing about Jordan is it says it's 18 months for cases in provincial courts and for traffic tickets, by the way, and for preliminary inquiries, in courts without a preliminary inquiry, and 30 months in other cases like an indictable offence.
Yeah. Like you really can't be putting off, say, like a aggravated assault or something for more than 30 months.
Yeah. And the point being, if you think about it, that if you're arrested, okay, there is two things at play here. First of all, um, if you commit a crime, it doesn't mean 30 months from the date the crime was committed. So
No,
you say you committed the crime on the 1st of January 2025. You can't be celebrating, hey, we're now 36 months into it. I can't be tried for murder of that person I killed on January 1st, 2025.
it's usually from the moment of arrest.
Yeah, it's from the
Yeah,
moment of arrest. Yeah.
yeah, and then they start doing things. They got to put it into the
Well,
system. They have to process it, and then you get some court appearances, and there has to be some procedure. It has to move along progressively towards
yeah,
some type of resolution.
yeah.
And I've been in cases where through provincial court they really don't like people adjourning things and adjourning things and adjourning
Well,
things ad
exactly.
infinitum.
I was in the provincial court not too long ago, for substituting for somebody else, and I was looking at some of these cases, and the justice was saying, "Well, I'm sorry, but this case is now it's been back here on the fourth edition of being back here, and you're not ready." I'm sorry, you're going to have to, Madam Prosecutor, you're going to have to be set in this next occasion is for defining a date for trial. I'm not going to accept anything less,
Hmm.
because obviously the judge is looking at that, or the justice of the peace is looking at that and thinking to himself, well, I can see the clock running on here. We're now 3 months away from a potential, Jordan challenge.
Yep, exactly. Yeah, we have a commenter, Paul Alexander, and he also said not only just a moment of arrest, but also moment of charge, because some things you don't get arrested for,
Yeah.
right? But you get charged with like speeding or something like that. They have to
Well,
have that
the
resolved.
point, yeah, it's the moment of charge because of the fact that, as I said, the you committed the murder on the 1st of January 2025. You might be 65 years of age before they actually figure out. And essentially it goes away and comes back, and it's not until something happens that a new piece of evidence pops to light, and the moment of the charge, so it's an open case no matter how long it's gone on for, you know and that's true with all criminal cases in Canada.
Yeah. Yeah, we've had like you're going in there like because you get arrested and you get charged. Hey, they're two different things. Hey, but definitely you get arrested. What am I being charged with?
Yeah.
Hey, so there's always these sorts of things, and then there's other times you get stopped on the side of the highway. You're detained, and then they charge you with some kind of driving offense or whatever.
And it's not necessarily to the minute, by the way.
Yeah.
If you happen to be charged on the 1st of January, even if it was at 22:55, and you're not and you're not, if the court has to actually finish the case, you have to be finished prosecuting and the judgment decided by that date.
I would think that at least get it to trial by
Yeah.
that time. Okay? If you're not haven't come to some settlement
Well, no,
arrangement.
there's been more recent cases about this. I forget the name of the case, but there has been a more recent case
Hmm.
indictable about getting it to trial. As I say, with many of the summary offences, they're very they're very very hard on the 18-month timeline.
Weren't they? Wasn't there a whole bunch of cases just thrown out because they were there
Yeah,
too long? Yeah.
exactly. There was, in fact, because of the um, COVID um, issues, there was a whole bunch of cases that were just tossed
Oh
recently.
boy, people might have been happy, quite happy then.
Well, yeah, but again, I don't think, let's be honest, they were not indictable offences. So they were not the serious
Yeah, they're
crime.
usually provincial offenses
Yeah,
or
they're the offences that you would have gotten 3 months in prison for at the most.
yeah. Yeah,
Right?
they have when they're talking about a delay, a definition of delay is does not include any time that the defense has asked for, say, an adjournment,
Yeah.
and then they waive 11B. This often happens.
Well,
Okay?
and
Or
especially if the defence is trying to get hold of a person. I've got Mary Jones. She's my witness, but every time I've gone to, every time my detective's gone to her place, she's never there in Ancaster.
yeah. So these are things that could possibly, where they have to evaluate, and this causes a net delay calculation in
Yeah,
terms of the R versus Jordan.
yeah. And in fact, actually, as you well know, one of the first cases I dealt with here, it was a building code matter, but it was still, of course, a summary conviction charge. It was eventually the 11Bs had been swung by the defendant on many occasions. Right, so
Mm.
it was 4 years old by the time I got it. And I'm
That's
having
when you're
to,
sinking your teeth into municipal law.
yeah, that's when I'm having to calculate the 11Bs, and it's like, I didn't know I was going to have to get an 11B calculator.
Yeah, if we had to look at that, because it does very clearly say on the court record about who caused the delay.
Yeah. Oh,
Yeah,
yeah, and it's very clear about that. And
yeah,
unfortunately, on the case that I had, the delay was being caused by the accused father.
yeah, exactly. Yeah, and this is something where the courts always say, stop playing games.
Yeah,
Okay.
yeah, and
In civil
actually,
court, they say it's called peremptory. You can't have any more adjournments, and they make it peremptory on the party that's causing all the delays.
yeah. And the point being is that once I spoke with the prosecutor and got on this case, I spoke with the prosecutor, we managed to move things forward. We had a schedule of things that had to be done, and we just proceeded through the things.
Yep.
And then we put it in front of the court once we were ready and we had the fait accompli. And the court said, well, the actual justice said, I'm glad to see this one has come to an end.
Hmm.
Right. And it was an amicable solution which
Yep.
worked for the
And
prosecution.
that's what happens when you get legal representation.
Yeah,
This guy was going without legal representation for how long?
yeah, oh yeah,
And they
yeah,
think they can
exactly.
just delay it forever and think it's going to go, oh, Jordan's going to make it go away. No, it isn't.
Yeah, because the prosecution isn't going to make that mistake.
Yeah. Yeah.
Even
Prosecution
if
is
you
very
do,
careful in these things.
even if you and the self-represented defendant do. Okay, so moving on to another one. You're going to have to pronounce this one because I don't know.
Tranchamonte. Okay. And this one was a case where there are two individuals, one of whom I think there are two alcoholic individuals who were trying to apply for ODSP and were denied. At one time, there was in the legislation that if your disability was solely due to some kind of substance abuse, right, that this did not define you as being disabled. Okay? We used to have to go around it in some way. So if somebody had an addiction issue, but the addiction, for example, caused cirrhosis of the liver, or if the addiction caused some other mental health problems, we would be able to get them through on the ODSP. But some people decided to say, well, look, there are people who are very seriously addicted to alcohol,
Mm.
or seriously addicted to some other drugs, like we all know about the opioid crisis.
Yeah, yeah.
Okay? So this sort of thing. So a lot of them, they can't help it. They have also got under not under control. So what
But
happens
there's
is they all went all the way up to the courts. And this went all the way to the Supreme Court of Canada after it winded its way to the Divisional Court, to the Ontario Court of Appeal, and up to the Supreme Court of Canada. And the
which is
Supreme
why
Court of
down there
Canada,
it says SCC 14,
yeah, exactly.
Supreme Court of Canada.
Yeah. So, and this time they said this is a human rights violation because addiction is considered a disability. There were all kinds of cases, Intra versus Imperial Oil, those kinds of cases that were also relating as addiction being a disability. And on itself, people having to accommodate people who have an addiction in the workplace. And there's a lot of that being talked about. And this time, addiction is also equitably be considered a disability. So they said, and they used the Human Rights Code to do this. And they said, oh, well, you can't be using the Human Rights Code and argue this type of thing in this Social Benefits Tribunal. Social Benefits Tribunal is only supposed to look at what the law is written as. No, they said when you have to look at the law for any tribunal, not just a social benefits tribunal, but any tribunal at all, human rights code and other aspects of the law must be considered.
Yeah,
So if there's something going on that could be charter based, even though you can't really do charter based through the SBT, but human rights tribunal you could, but some of the other tribunals you may be able to use charter based arguments. So this is a very, very powerful decision that's changed the way a lot of tribunals look at things, including the Landlord and Tenant Board. You can now put things through on the Landlord Tenant Board making human rights arguments when you weren't able to do so before. Okay, so this is a very important case that came up. Okay, and
okay.
that's
But
fine.
it would seem also fairly controversial because, of course, there's a lot of people out there, and I'm not saying the right or wrongs of any of this. There's a lot of people out there that believe that, hey, just because you are an alcoholic, you shouldn't get away with.
Hello?
I'm here.
Yeah, just because you're an alcoholic, you can't get away with what?
Sorry. The question was about whether there are some people who are saying that just because you're an alcoholic, you can't claim it, you shouldn't be able to claim it as a disability and therefore excuse yourself from certain things you do.
Yeah, and this is something that's always taken into consideration. There's always a balance in the law. For example, you can claim you're an alcoholic, and then you get behind the wheel and you drive, right? And you say, well, I'm an alcoholic. I should be able to not be punished for this. No, you can't. That can't be used, right? Because there's a balance that's weighed in the law,
Yeah.
right? But this was done for people who are claiming disability, and this is another example where the Supreme Court rewrites the act, rewrites the legislation.
Yeah.
Right?
And actually, it's not about rewriting the legislation per se, but it's about interpreting it and giving it a um, more substantial meaning, I guess.
Yeah, because the legislation actually said that substance abuse was not a disability,
Yeah.
so they had to get rid of that. Same as what the Individual Rights Act in Alberta, when somebody went and they tried to sue on the basis of that they were dismissed from their job because of the LGBTQ issue. And then the courts at that time, the Individual Rights Act in Alberta at that time did not have any provision for sexual orientation. So what happened is the court was overruled, and that was overturned, and they wrote sexual orientation into the Alberta's Individual Rights Act. So this is what the court has a power to do,
Yeah.
right? And it's a consistency, part of common law. It's a consistency. So across the country, it all has to be the same when you're deciding on similar factors.
Yeah. Okay. So, of course, you know me and looking at history. So I look
Oh, yes.
up and I go this question about having done all of this stuff, and I said, "What's the oldest case law in effect?" And so what did I do? I go and find out this case called Furrer and Snelling. It's a
Oh, God.
landlord and tenant matter dating from 1220.
Yeah.
I've got to change my thing. I'm going to find a reason to put Furrer and Snelling into my case law for the LTB now, don't
Oh,
I?
yes. I bet you nobody's heard of it.
Syndication's going to go, you what?
I'm going to be a fly on the wall when you make that argument.
And hey, I've not even read this case. You know, we talked a while back about some of the ancient laws that existed. So, for example, ancient Egypt's legal concept, the Ma'at, goes back to 3000 BC. The Sumerian code Unamu goes back to 2100 to 2050 BC, and the Babylon Code goes back to 1760 BC.
Yeah, and what the most commonly known as the Hammurabi Code, things like that.
Yeah, yeah. There's a lot of those, yeah, Hammurabi Code that are all in there. Yeah, the Babylonian Code, Hammurabi, is actually its more common name. Yes, you're right.
Yeah.
Yeah, yeah. But again, hey, so there's another one, and then we come across this other one here. So actually, so where was it? Okay, so Ferrer and Snelling, the case came to £100 in unpaid rent. The judge ruled that in covenant damages, the covenant damages are only to be recovered. Where more is demanded than is due, the debt only is to be recovered.
Back to, back to Furrer and Snelling.
Yeah,
Yep.
that's
Because this is interesting because there's a lot of history and precedent that bases on commercial tenancies too.
yeah,
Because this is also the root of commercial tenancies. Residential tenancies and commercial tenancies taken a
yeah,
divergent
yeah,
since then. But it's very interesting to look at how that is about the use of distrainment and the use of collections and that sort of thing. You can't be doing more than one of them at the same
yeah,
time to be able to do this. So it's a very common type of element because you can't put a person. Because I had a case one time back in I think it was 2006 or 7 or something like that, and I argued it was a commercial tenancy. My client's business had about almost $1 million worth of equipment, and he was located around here, and he was just doing it. And the commercial landlord just decided that he did about $350 damages to my premises. Of course, they have to notify them under the act about anything that's outside of rent. Okay? So this came up with perspective of the damages, but there was no notice. The guy just locked him out and said, "You owe me this much." Okay? And this guy tied up his equipment for several days, which was worth a lot of money to him. Okay?
but
So
the loss of the
yep,
loss of non-productivity must have even
yep,
been higher than
yep,
the damages for
yep.
the damage.
Yeah, so he tried to sue him as well as hold up, which is called distraint for the equipment, and to
Yeah,
lock up out so he wasn't able to work. So I argued. So I used case law. I don't think I went back as far as Furrer and Snelling. Okay, maybe I should next time. But, but however, this one actually was interesting because I won my case. Not only won my case, but I got full costs from my client.
yeah, yeah,
Okay, and
Good.
people who do these things. They have to be very careful. And I also suggest, if you're a commercial landlord and you're upset about something, it's best to try to work it out with the tenant. Don't get into these matches like this because it's just going to cost them more in the long run. Because you'd rather have a happy tenant paying rent and staying there, and also promoting other people to come in.
Okay. So moving on, the case of Thorns in 1466, or otherwise known as Hull and Orange, which basically is the first known case where a common law court applied the foundational principle of tort law, ruling that an individual who suffers damage from action of another, even if those actions were lawful, is entitled to compensation.
So this has nothing to do with the Game of Thrones with George Martin or anything.
Nothing.
No, interesting.
Nothing. But I suppose it's a thorny case
A thorny case. Yeah.
involving tort law, and
Yeah.
this has got to be. I wouldn't be surprised if I were to ask this of Scott McEachran. He'd go, "Yes, I know that case. It's this." And he'd
Oh yeah,
give you the case history
Scott
of it.
would be someone who would look it up and all these strange, archaic cases he would come up with. He would look them up.
Yeah. Well, there you go. Okay. So, and there's a few cases that I quite love. I think this one is actually one that's important to actually the way we do shopping today. It's a British case, a Pharmaceutical Society of Great Britain versus Boots Cash Chemists Southern Limited, 1953. That's a few years before I was born. And
Although this is
basically,
a newer case than the other ones.
yeah, and this is actually a case of what's called offer and acceptance. So when you go to a supermarket, when does offer and acceptance occur, Angela? So when I put the produce in the basket, so here's my basket, here's my produce going in the basket, right?
Mm-hmm.
When do I make an offer? Am I making an offer when I'm putting it in the basket, or am I making an offer when I take it to the till?
Then they go into the till.
Exactly.
Somebody's accepting it.
But you see, the Pharmaceutical Society of Great Britain said the point at which you put the product in the basket is the point at which you're making the offer and acceptance.
Mm.
The trouble is with their approach is that they forgot the interpretation of the cashier in that process.
There's also offer to treat too. There's different steps you go up
Another, yeah, the invitation to treat is another question entirely, because what that's about, what's on the showroom window of the shop.
Yeah,
But
I like this. I like this ice cream, so I want to buy it. And then you get towards the counter, say, no, I don't want to buy this ice cream after all. I need to lose weight. Okay, I'm putting it back.
yeah, you have a guilt conscience come
Yeah,
in.
exactly.
Yeah, I need to lose weight. My doctor's going to be killing me for the next week if I buy this
Yeah.
300-pound tub of ice cream.
Exactly. So I mean, that's why I would say, that once you get to the kill, I made a decision, okay, and then they, ding, ding, cha-ching, you're done.
Yeah, and the point being is that they were trying to argue. They were trying to argue that the pharmaceutical society, that Boots did not have the right to actually sell many products on the shelves, particularly pharmaceutical type products, because they didn't have a pharmacist in control of the cash system. But in fact, the House of Lords basically agreed with Boots the chemist and said, no, there's a pharmacist available, and if the cashier needs to have something authorized by a pharmacist according to the rules of Boots Cash Chemist, they could easily press the button and hold it up and have the pharmacist come to the counter.
Mm-hmm.
All right. In fact, you think about this, this is the whole foundation of how we do supermarket shopping today.
Interesting.
right?
That's always an interesting concept about how these things develop, and you show how they mature over time.
Yeah. I'm also interested, and I didn't do beforehand. Um,
It
the
even had a
supermarket
Pharmacy
shop
and Poisons Act at that time.
supermarket shopping laws in the okay. So the federal law, like Robinson-Patman Act, um, yeah. So they basically put an antitrust laws, food safety laws, etc. They didn't. Yeah, so they basically had the Robinson-Patman Act, which addressed price discrimination, and local authorities are overseeing food waste, safety, waste management, etc., etc. Um, yeah, so those are quite old.
Yep.
Yeah, so yeah, so there we go. There's not. I don't really have any case law in terms of U.S. law, but I'm sure there is. I just didn't have time to research it. Right
Yeah.
there we go.
Sometimes you go in there and then there's fine law, things like that. You can go through the US or
Yeah,
Westlaw. Westlaw has a US component.
yeah. And the other question, therefore, well, in fact, probably if I'd have done if my query was, what is the US equivalent of Pharmaceutical Society of Great Britain versus Boots Cash Chemist, it would have probably told me,
Hmm.
right? Okay, so moving on to a Canadian case, Elbridge versus British Columbia, charter obligations,
Yep.
positive right to provide accommodations for people with disabilities.
Yep.
And this,
And this is where a lot of people get things messed up with the charter.
yeah,
Okay. Because the Charter of Rights and Freedoms generally has, by practice, not necessarily by law, but by practice, has been enforcing what we call negative rights. Negative rights are, okay, the police don't have a right to frivolously search you for no reason. They don't have a right to pull you over for no reason. You have a right to have people not listen in on your private conversations. These are rights for you to be free of somebody interfering with your life in some way. Okay? Eldridge was kind of taken a bit different from that because this had to be a person who was going into labor and then she had some complications of labor. It was a deaf lady, going into the hospital in BC, and they didn't use American Sign Language, which was how her communication would be. And this became and complicated her healthcare experience because she didn't have good communication. So at the end of the day, after it went to the Supreme Court of Canada, it said the government has a positive right, a positive obligation to provide accommodations for people with disabilities in terms of any kind of service or organizations that it is involved in. So whether it be healthcare, equal rights. And I think Peter's trying to figure out what keeps going bleep on this thing.
I can't. I don't know what it is. I had trouble with the landlord and tenant board today, so I'm just imagining that our internet's slow. Okay,
Yep.
so
The other
just
thing too is when you
okay,
talk
just
about
repeat
positive rights,
yourself.
there's another decision that
Just
actually came
repeat
out.
yourself on this positive rights thing in relation to Eldridge, please, because I think it got lost.
Okay, the positive rights. Okay, when you have a Charter of Rights decision, most of it's about negative rights. As I said, the freedom from
Yeah,
interference with your life and so forth. But a positive right is where the charter says the government must, like with any kind of facility or services that it provides to the public, it has to provide accommodation for people with disabilities.
yeah,
Even if it had to provide an ASL interpreter for the lady who had to go into labor and to prevent these sorts of things. Similarly, there was a case called Cheoli in out of Quebec. I guess that's how it's pronounced. But this was a gentleman who needed some surgery. It wasn't urgent surgery, but it was one of those types of surgeries you wait and wait for. And he was in pain. And he was complaining, and he went all the way up, and he was wanted to go out and try to take a private option. So they were putting some pressure on the healthcare system then about it. So the Supreme Court said the answer is not making private healthcare, but the answer was let's look at the healthcare, making sure that we're not putting people in that position, that
Yeah.
we are going to offer them an alternative. So even if we have to pay somebody to go to another country to get treatment or to get care at certain way so that everybody would have reasonable access. So it was interesting about that. So when you're talking about positive rights, there are things that could in the future become like, especially the Goslin decision against Quebec, where a woman was suing Quebec because of low welfare rates.
Yeah.
So there's a lot of different things where these things do come up, and these things have to be further litigated to be able to be further hashed out, especially under Section 15 types of issues.
So before we go further forward, I just want to go back to this Boots case. So I did a search in relation to US. There is no single US case that replicates the Boots case. The principle established in Boots regarding the invitation to treat, offer and acceptance, the formation of contracts is reflected. This is identical in American law as it is in British law, particularly in the context of self-service retail. The key takeaway from Boots is that the display of goods is is not an offer, but rather an invitation to treat.
Invitation to treat.
Well, well-established principle both in Britain and the US, and of course that means Canada, Australia, and everywhere else.
It's like our website.
So,
We offer
yeah,
legal services. People can read about what we do, but doesn't necessarily mean it's a contract.
yeah, exactly. Yeah, exactly. Anything else further on this human rights one?
This is very interesting because the Goslin case was about a person who was in Quebec. She was talking about the Quebec welfare system. If you were older than 30, you got more welfare than if you were younger than 30, I think, at the time. And she was younger than 30, and she was complaining that this left her in a very, very desperate circumstances where she was to the point of selling her body and other types of things
Yeah.
for base survival. This eventually went up to the court because we do have people that will fight these types of battles. And it went up. Remember, Quebec is also under the civil code, so that can complicate things. And they have their own charter.
Yeah, and that
Yeah,
actually does complicate things because not
yeah,
everything that matches on the Quebec civil code necessarily has a 100% place in
yeah.
under.
It doesn't always match glove in hand.
Yeah,
Yeah. So she went up and she argued this, and it went all the way up to, I believe, up. It went to our Supreme Court.
yeah.
But again, they have to use what Quebec has, and they did. That was a split decision actually. It wasn't a full decision.
It doesn't say
Okay, it
that
was
it
a
was a
split
split.
decision.
Yeah,
Yeah. So what it did say is the one person who did say Louise Arbour actually wrote the minority report on that, and I thought that was very very important because they start talking about how there could be in the future in terms of positive obligations on the part of government to just ensure that people aren't going to be dying or starving to death or whatever. I don't know. It's but we haven't even got there yet. But I think that this is an area that could be explored.
yeah.
Right? We have a legislative right to housing, but we haven't even got to the point where any of it has been litigated, even
Hmm.
though they tried and
Yeah.
it didn't go anywhere.
Okay. So, since I was looking at old cases again, the oldest case in the Supreme Court of the United States was 1791, and it is West versus Barnes, and it's primarily about court procedure.
Oh, yes.
But basically, the Supreme Court was like, well, days old when it was when the decision was made.
Hmm.
Right, so literally, they came in. I think the Supreme Court's second year. So it's 1790 was the original year of the Supreme Court.
Hmm.
And so they'd probably only just got the judges into seats and said, "Hey, you're sitting there."
Yeah.
Now here's the
It's only 1787 when they started putting everything together for the U.S. And then they
yeah.
had to establish its Supreme Court, and that takes some time.
Well, and then you've also got courts like Marbury and Madison, which is a landmark case establishing judicial review in the U.S. And it's not the oldest one, but hey, that's 1803, right?
Mm.
Okay. And moving on, of course, then the question rises: what's the oldest case in Canada, in the Canadian Supreme Court, which is again Kelly versus Sullivan, 1876, when the Supreme Court of Canada was also fairly new.
Hmm. Yeah, that's always interesting. It's
Well, I
always
suppose you
that
don't
what they
have a
do.
court which doesn't have cases in it, right?
Yeah, because the thing is, when you start and you open a court, you got to start having cases. Somebody
Yeah.
has to eventually go there and have
Yeah,
a
you
case.
can't sit there and you can't have the person at the front desk sitting there twiddling their thumbs. Oh, I hope somebody comes in today with a case for us. Cry my eyes out if they
And
don't.
then they have to base their cases on things because they have to get them from England for a lot of things.
Well, actually,
For importing stuff.
yeah. So the Supreme Court of Canada was set up in 1876 before Confederation. In fact, um, realistically, the Privy Council would have been the Supreme Court of Canada at the time.
Yeah. And then our independence of the Supreme Court to decide was in 1982 to
Yeah,
decide on Charter of Rights issues when we moved our own charter and constitution.
yeah, and it was weird because actually, while the Supreme Court of Canada was the upper court in the land, it was possible to get leave to appeal to the Privy Council,
Hmm.
right?
Yeah.
Which is daft, really. You
Yeah.
know,
You have to go across the ocean and go
yeah,
talk.
just to go across the ocean. Yes, and here you go across the ocean and you're all going on the same ship, aren't you? You got the two parties who hate one another gradually getting used to one another on the ship, aren't they?
Yeah. Oh, yeah, right. Imagine that.
Yeah, yeah.
There's so much interesting things when you look at the case law and the common law and how that affects us. So that's why we can't just go to court and then expect anything to happen or convince a judge that he'll see everything our way and that everything's automatically going to be doing it. And
Well,
nor is it fixed. Okay, so these things have to be shown where there's a logical flow of
yeah.
process, logical flow of precedent,
Well, there
okay,
was
to make these
in the
arguments.
in the court today. I had the person opposing me. She suggested that a particular case would apply, and I actually pointed out before she actually had the opportunity to make her arguments about why that particular case applied, because I was up first. I actually gave argument as to why that case would not apply.
Yep. And then the adjudicator said it's not your issue to prove the case doesn't apply, but her case to show how it does.
And the interesting thing is, she did not really.
Hmm. And this is where
Um,
you have to be very, very clear when you're arguing case law. Many
yeah,
people who like to do this, they will argue their case law, and that's fine. It's very important to make sure you understand what the case law is about, what the principles are, what the legal effect of that case law is, okay,
yeah,
when you want to use it. Okay, a lot of people say, oh, well, I'm just looking for something where the same thing happened. No, no, no. You're testing principles. You're testing issues of
Well,
law.
in fact, actually, there's a the question about, you see, take for example Jordan, right? The
Hmm.
question about Jordan isn't that you're being tried for the same type of criminal offence that Jordan committed.
Hmm.
Nothing to do with the criminal offence that Jordan was committing, allegedly committing. It's all to do with the timing and how long the prosecution has taken in order to bring that case to court.
Yep.
Doesn't and it doesn't matter whether you it doesn't matter whether your case is about illegal tomatoes being grown on a hillside and marketed to people in British Columbia. If it's a crime, you can be arrested and tried for it. It's it's not about that,
Yep.
right?
This is why you have to know what to look for, what phrases to use, what tests you have to prove, that sort of thing. And
Yeah,
that's when you do a search for case law. Right? And this is why a lot of people they struggle with that. That's like when I was looking for the definition of child. I don't go look up what is a child under the RTA. No, I say what is the definition of a child in Canadian law.
yeah.
Right? So I look under that, and then I look under other things where there could be other definitions. And basically, it tends to follow family law and the Children's Law Act, Children's Law Reform Act. Yeah.
And just to answer that question, what is the definition of child under Canadian law? I get
Mm-hmm.
the thing back. Under Canadian law, a child is generally defined as a person under the age of 18. This definition is consistent with the UN Convention of the Rights of a Child, which Canada
Mm-hmm.
ratified. However, the age of majority and the age at which a person is legally considered an adult can vary from province to province.
Yep.
Right? For example, in the age of majority in Ontario, I believe is 19, not 18.
Yeah, like for drinking age usually.
Yep.
Some
And
jurisdictions that's 21.
sorry,
Some jurisdictions that's 21.
yeah, not. I'm just basically put that up there. Okay, so and again, it's 21 in the US, for example.
Yep.
Yep.
Yeah. So
Um,
these are things to kind of look at and to be yeah, and that's what you do. Just kind of looking at that. Okay, how can I make an argument? Okay.
and the argument that we were looking at was whether a particular child, what the child to parent relationship was.
Yeah, exactly. And it didn't look like something that was a settled intention.
Yeah.
Okay, so we want to look at a settled intention.
Yeah.
Okay, to
Exactly.
raise that child as their
Yeah.
own.
Yeah.
Okay? Doesn't have to be a biological child.
Yeah. Exactly. Okay, so so that's been an interesting run around case law.
Yep.
And the trouble is, we've only touched on we've only literally touched on a bit here and a bit there and a bit there and a bit there. Really, there's probably in this entire square, there's probably more space than I filled in with the cases that I've connected, right?
Yep.
So just be aware of that. So if you need legal advice, you can contact us here at Invictus Legal LLP, calling us on 905-688-5598. Email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal, or go to our website, weareinvictus.legal. And Angela, I know you love this one.
Oh, yeah, right. Okay. Yeah, just don't sue us. What you've heard today on Spin Legal, whether on this show or in others in the series, is not legal advice. Okay? You can't be listening and say, well, I heard this on Spin Legal that I can do this. No, it's not legal advice. It's the same as Facebook University or somebody getting their Google medical degree. Okay? It's not legal or medical advice in any way. If you need legal advice, then you need to contact a paralegal or a lawyer that they're licensed to provide you with legal advice in their respective areas of law and practice.
Yeah. And I guess we will be back next Tuesday. and have a great week, and enjoy yourself and stay legal.
Yep, stay legal.